Summary of TCC Judgment 114, Shenpan 1, 2025. Case on the constitutionality of the amendments to the Constitutional Court Procedure Act. Handnotes. As the constitutional judiciary enjoys the procedural autonomy conferred by the Constitution, it shall not be constrained by procedural law if it impedes the exercise of its competence. The fixed number quorum under Article 30, Paragraph 2 of the Constitutional Court Procedure Act, CCPA, shall not be applied to review its own constitutionality. Instead, Paragraph 1 of the said article shall apply in terms of the quorum and the decision threshold. As a last resort to maintain the functioning of the constitutional judiciary, the three justices who have continuously refused to join deliberation were deducted from the number of incumbent justices when calculating this case's quorum. Upon reviewing the legislative records, the change provisions, 7 provisions in Article 4, 30, and 95 of the CCPA, legislative process was found severely flawed, violating the due process of decision-making, of lawmaking. All the impugned provisions were declared unconstitutional for violating the principle of separation of powers. In its reasoning, the Constitutional Court held that the Legislative Yuan overreached in imposing additional obligation on the President's constitutional power to nominate constitutional justice in Article 4, Paragraph 3 of the CCPA, hereinafter Provision 1. The unreasonable fixed number deliberation quorums and decision threshold set by Article 30, Paragraph 2 of the CCPA, hereinafter Provision 2, without the complementary measures, were declared unconstitutional for hindering the justice from exercising their competence. Paragraph 3 of the said article, hereinafter Provision 3, was declared unconstitutional for unreasonably allowing dismissal on the ground of insufficient quorum, which negates the purpose of constitutional adjudication. Paragraph 4 of the said article, hereinafter Provision 4, applies Paragraph 2 quorum to preliminary injunction orders, impeachment cases of the President and the Vice President, and the cases regarding the dissolution of the political parties, negating the additional article of the Constitution's design on the matter. Paragraphs 5 and 6 of the said article, hereinafter Provision 5 and Provision 6, were also declared unconstitutional for establishing a baseless quorum for the constitutional judiciary when specific recusal numbers occurs. Article 95 of the CCPA, hereinafter Provision 7, was declared unconstitutional for wrongfully deleting the date of enforcement for the 2 previous amendments, in violating the Central Regulation Standard Act and the principle of legal stability. Background note: on December 20, 2024, the Legislative Yuan passed the amendment bill to the CCPA. The bill amended 7 provisions in Article 4, 30, 95 of the CCPA. The amendments require the President to nominate the TCC candidates in 2 months when there is a vacancy. Provision 1, as well as adding additional quorum threshold requirements for the Constitutional Court to deliberate, declare unconstitutionality together in Provision 2, order preliminary injunction, uphold the President and the Vice President's impeachment, and dissolute unconstitutional parties, together in Provision 4. The amendment bill also added procedural rules for situations in which the quorum is not met, including those result from recusal, Provisions 3, 5, and 6. Lastly, the amendment also designated December 20, 2024 as the date of enforcement, while deleting the enforcement clauses for 2 prior amendments to the CCPA, Provision 7. The Legislative Yuan deemed that the provision unfeasible and request the Legislative Yuan to reconsider. On January 10, 2025, the Legislative Yuan upheld the original bill by majority vote in plenary session, denying the executive yuan's request to reconsider. On January 13, 2025, the legislative yuan sent the amended provision to the president for promulgation. The provisions were promulgated on January 23, 2025. 51 members of the legislative yuan believe that the newly amended provision of the CCPA were unconstitutional for the flaws in legislative process and for violating the separation of powers. They filed a petition with the TCC on June 15, 2025, because the new quorum would leave the court unable to deliberate with only 8 justices. The petitioners also motioned for a preliminary injunction to suspend the implementation of change provisions. On May 12, 2025, the TCC held a public hearing and summoned relevant parties and experts to provide their opinions. The above-mentioned events happened against the backdrop of the ongoing rotation of constitutional justice. On October 31, 2024, 7 constitutional justices, including the president and the vice president of judicial yuan, ended their terms. The president of the state had previously nominated 7 candidates on August 31, 2024, but the candidates were all denied by the legislative yuan on December 24, 2024. The second group of candidates was nominated on March 21, 2025, but were also denied on July 25 of the same year. The circumstances left the TCC with only 8 justices since November 2024. Summary of the judgment holding. 1. Provision 1 stipulated that when the number of incompetent justices falls short of the number prescribed in Article 5, Paragraph 1 of the Additional Articles of the Constitution, due to expiration of term, resignation, removal from office, or death, the President shall submit nominees for vacancies within 2 months. Provision 2 stipulates the number of justices taking part in the proceeding under the preceding paragraph shall not be fewer than 10. When a declaration of unconstitutionality is rendered, the number of justices in majority shall not be fewer than 9. Provision 3 stipulates where the proceeding cannot be commenced due to a lack of quorum, as described in the preceding paragraph. The Constitutional Court may issue an order dismissing the petition by a majority of the total number of incompetent justices. Provision 4 stipulates where the Constitutional Court renders a preliminary injunction order pursuant to Article 43, a judgment upholding the impeachment pursuant to Article 75, or a judgment dissolving an unconstitutional political party pursuant to Article 80. The quorum and the decision threshold as prescribed in the 2 preceding paragraphs shall apply. Provision 5 stipulates where the number of justices recused pursuant to Article 12 of this Act exceeds 7. All of the justices who are not recused shall participate in the proceeding, and a judgment or an order shall be rendered only by 3/4 of the non-recused justice. The requirement set forth in paragraph 2 shall not apply. Provision 6 stipulates where the number of the non-recused justices referred to in the preceding paragraph falls short of 7. No case shall be adjudicated. The Provision 8 stipulates the provision amended by Legislative Yuan on December 20, 2024 shall come into force on the date of promulgation. These provisions, as promulgated on January 23, 2025, are majorly flawed in their legislative process, violating the constitutional principle of due process of lawmaking. The provision also violates the separation of powers under the Constitution. The provisions shall cease to be effective from the announcement date of this judgment. 2. The previous version of Article 95 of the CCPA, before the changed version as promulgated January 23, 2025, shall continue to be applicable. 3. Preliminary injunction application of this case shall be rejected.